Welcome to IP in 5. I'm Aaron Jin, a partner at MBHB, a full-service intellectual property law firm. In this series, we discuss the most interesting and challenging issues in the world of patents, trademarks, and more. Today we're discussing design patents, and I'm joined by my colleague and fellow MBHB partner, Dunstan Barnes. Welcome, Dunstan.
Thank you, Aaron.
So Dunstan, most of us at MBHB work in the utility patent world. Your expertise is in designs. Can you tell us a little bit about the differences?
Certainly. So utility patents are usually what people are talking about when someone says, I want to get a patent, or we're talking about patents, and they protect the way something functions, the way it works. In contrast, design patents protect the way that something looks, so the ornamental appearance of a product.
So how can designs and utility patents be used together?
When someone comes up with a new invention, whether it's for a new car, smartphone, there might be parts of it that are protected by the new function, the way it's working, and there's also the visual aspects. And so you can protect both aspects of that. You protect the functional part with the utility patent and the ornamental part with the design patent.
So the way I understand it, design patents focus on the ornamental design of an item. What about when the ornamentation has a function?
So actually, function is a requirement for design protection. If there's no function to the item, you're really talking about the realm of copyright, right? So it's like purely artistic. Design patents protect things that have both a function, but they have an ornamental appearance.
So designs don't have to be non-functional to be protected by a design patent.
Right. Designs don't have to be non-functional. They have to have some degree of function, can't be solely dictated by function.
So what part can design patents play in a company's overall IP portfolio?
Companies these days often don't want to just protect the way things work. They get upset if people copy their products. And design patents are a very effective tool against copycats or similar imitators of the overall appearance.
Thinking internationally now, how are you counseling clients with regard to design patents and design rights strategies?
Some of the counseling is probably similar for what would be advising clients for international utility protection. And if the visual appearance is important, it's worth protecting it abroad.
So if a company is thinking about going into specific countries with design protection, when does it make sense to file under the Hague Agreement?
The Hague Agreement has been available in the US for about the past 10 years. For more complicated designs, it may make sense to utilize local counsel to take advantage of the expertise of local counsel and the nuances that occur in that jurisdiction. But for more straightforward filings, the Hague system can be a really effective way for applicants to save money.
So from the Davis cases on the utility patenting side, we know that only a human can be listed as an inventor. How does that work with design patents?
Well, in the US, designs are under the patent system. So it's the same rule, only humans can be an inventor of design patents. In contrast, in Europe, designs are under a registration system, and it's not under the patent system. There's no requirement to name an inventor. Philip Stark came up with an AI chair that was developed as a collaboration between Stark and generative AI. In Europe, they didn't name an inventor, but in the US, the sole inventor that was named was Mr. Stark. Now, the way that this AI chair was developed was Philip Stark described it as having a conversation with the AI, and the goal was really to minimize the amount of material that was used in producing this chair. And the AI chair, as it's known, is commercially available today.
So Dunstan, I was listening to your presentation recently on design patents, and you were saying that a title of the design patent is very important. Why is that?
In the US, the title has become crucial in the past 10 years or so. It's due largely to an amendment in the MBHB. That's the manual that's used to examine design patents. And about 10 years ago, it was amended to state that the title may affect the scope of the design patent. Picking a title that is too narrow will limit the rights of the patentee. The choice of a title that is too broad can lead to an objection or rejection from the patent office. It also opens up the available prior art to that design patent.
Thanks very much, Dunstan, for sharing your insights on design patents. We hope this conversation has offered some new ideas on the important role design patents play in a broader IP portfolio strategy. Stay connected with us for ongoing analysis of intellectual property issues across technologies and industries.